All right, we're going to start our next panel. If everyone wants to take a seat. Okay, so our next panel on video game law features two experts in the field. We have Bill Chang and Dan, is it Nabel? Nabel. Dan Nabel are attorneys at Riot Games who recently published Video Game Law in a Nutshell for West. Bill and Dan will be in conversation with Aaron Moss, chair of the litigation department at Greenberg Glusker. Aaron specializes in content protection, including complex copyright and trademark issues. He's been named a leading IP litigator by the Daily Journal and Los Angeles Business Journal, and a power lawyer by the Hollywood Reporter. Aaron, I will let you take it away.
Great. Working? No? Yeah. Test. Hey, guys. All right, so we are going to talk today about some of the recent, and I'm talking really recent, within the last few months, developments in video game law. And in talking about this the other day, we decided to focus in on a couple of topics and do a little bit more of a deep dive so that you can get a feel for what's going on in this realm. And the two topics that we're going to discuss in depth, first, IP issues, and a couple of recent cases that raise a host of interesting questions that some of which have been answered, some of which have not been answered, that are really have the potential to change the landscape legally. The second area is going to be gambling, which has been a really big topic both within video games and outside of video games, and that's an area that that Bill Chang and Dan Nabel. Dan is really an expert on IP, and Bill is an expert on gambling, and we're going to be able to use them as a resource to determine where we're going, where we are, where we're going to end up. So first of all, we want to plug their book. They actually wrote. They are the authors of this nutshell book, Video Game Law. Are you making any money off of that?
Not enough to cover lunch today.
Is it available on Amazon? Okay, you guys can go buy it on Amazon. It's not one of these like $500 paperbacks, is it?
No, it's like under $50.
Perfect. All right, you guys can order it now. So let's talk a little bit, Dan, about some of the recent IP developments, and in particular, there's a long-running case that has just recently settled, the Blizzard and Valve Lilith Ucool case. Do you want to tell us a little bit about that one?
So this case was hanging around for quite a while. It has a really complex, long backstory, and I'll just give you a little bit about it because I'm sure a lot of you haven't even heard of this case. It started with a Chinese company which ripped off a bunch of characters from different franchises. One of the franchises was Warcraft, World of Warcraft, which is made by Blizzard down in Irvine. And they also stole some Dota 2 characters. Dota 2 is a MOBA game made by Valve. And sort of ripped off those characters, made a mobile game in China, did okay. It did well enough that yet another game company called Ucool in Menlo Park, California, decided to rip off that game. So you had basically a clone of a clone, and Lilith really got upset with Ucool. And so they filed a lawsuit in the Northern District of California for copyright infringement. And they were saying, well, these characters you basically stole from us, and you also stole our code. And there's this fascinating backstory about how they actually inserted code that caused the copyright notice to appear like during gameplay for the Ucool users to show that it was really Lilith's game because they were actually stealing the code. Right. Anyway,
and we're going to talk more about the kind of claims that Blizzard and Valve were asserting when we talk about NetEase and PUBG. But what was really interesting in this case is the defenses, right? So the interesting defense, main defense, I thought, was that essentially what you guys are claiming, what you are suing on, you don't actually own. What was the basis of that?
Right, correct. So I mean, the obvious problem for Lilith was that they had stolen the characters from Blizzard and Valve. And meanwhile, Blizzard and Valve are saying, what's going on? There's these two companies, suing each other over our IP. So then they tried to intervene in the lawsuit. They were actually forced to file a separate lawsuit for procedural reasons. And finally, they all got together in the same lawsuit, and the litigation continued. And the very first thing that happened with Blizzard and Valve is Ucool said, you don't even own these characters. Okay, so Lilith, you don't own the characters because you stole them from Blizzard and Valve. And Blizzard and Valve, you don't own the characters because they're not sufficiently, the phrase that we use is sufficiently delineated to be protectable. In other words, they're just standard characters. You've got things like werewolves or vampires or orcs, and these are not things which they're very common to fantasy games. They're not detailed enough to be protectable. They're not consistently portrayed the same way. And so you can see like some of the side-by-sides up here of like, how bad the visual similarities look in terms of the infringement. But this gets to the underlying question of, well, nobody owns a panda bear, for example, and was there really enough original expression there? And initially, Blizzard and Valve, I think it was a joint complaint, or maybe it was just Blizzard's complaint, was dismissed because they didn't sufficiently plead that their characters were essentially sufficiently delineated such that they could receive copyright protection separate and apart from the games in which they were portrayed.
Right, and what about what was the genesis of those characters originally?
Yeah, so that raises yet another question is, many of them were original creations, particularly in Blizzard's case. They did actually create these really cool original characters. But for Valve and Dota 2, while some of their characters were original creations, some of the characters were created by the community. And so you had this really interesting situation where I guess it was Ucool was arguing, you guys don't own these characters. The community that created these characters are the authors of these copyrighted works. And so there was an analysis that the court had to go through, and they sort of analogized to the film world where we've seen these cases before about who owns a movie. Is the actor who acts in the movie? If there's no contract in place, does the actor own a copyright interest in the movie? Like taking those sort of film concepts and applying them to video games, and sort of took this concept of like, well, who's the mastermind behind putting all these pieces together, and said that generally Valve was going to be the copyright owner for some things, but there were open issues for a lot of these other characters that a jury would have to decide.
See, now what I thought was really interesting about that, though, is that this all could have been avoided, right? This entire analysis of who is the mastermind, if there was terms and conditions or an end user license agreement that said anything that is created using the game engine, the game elements, is going to be owned by the owner of the game. And apparently there was not, and I think that there's been some pushback recently, game companies not wanting to assert that they have ownership interest in fan creations.
Well, that's tricky because in the case of Dota 2, what happened was the guys who were essentially owning the development, most of them locked down the version. So while people could contribute ideas by submitting them, they couldn't actually directly put them into the game. Sometimes you can have basically an editable version where people can be making contributions. Other times you have to like actively accept them, and that's where the court was saying that that sort of gatekeeping function is what, in those particular cases, made them the author of the work, because they're deciding what goes into the work. They're sort of locking it down and almost creating like a gold master, if you will, of like, this is now the game. But then you had this other body of things where people were publishing on the web or on blogs, like, hey, here's my idea for a character that should go in Dota 2, and describing all the attributes and what the character, you know, might look like. And then you have kind of an implied license question of, okay, well, if you put this character up on the internet with the intention of the Dota 2 people putting it into the game, did you give them an implied license to use that character, because that's essentially what you wanted? So this sounds, you can see this gets really complicated really quickly.
Yeah, it raises a lot of, you know, it's kind of like a law school exam, a lot of issue spotting in terms of any of these issues that come up, including one that you don't see very often, which is abandonment, right?
Yeah, and that was another one where one of these guys, I don't know if it was Yule or whoever, one of these guys, he was like 18 and wanted to go off to college and like not do this anymore. And so he said, I'm releasing this so that anyone who wants to work on this can do it and play it, and it's basically free, but you have to give me credit. And the court even analyzed his message to say, well, what did he mean by you guys? Did he mean like a specific group of people? Did he mean everybody? Was he really abandoning it? And that was the question where the court on summary judgment said, you know, the court's not going to answer that. We're giving this to the jury. Like, the jury can go figure out what did he mean by that? Did it meet the standard for abandoning his copyright interest such that he couldn't then assign it to Valve? So really, really cloudy issues, which is, again, why when you have, you know, a game like this, understanding where all of your characters, where all of your IP is coming from is very, very important, because once you get as successful as a game like Dota 2 and you have really cool characters that companies want to rip off, when you have these lawsuits, when you go try to enforce your rights, as Valve is doing here, these are the things we're starting to see, because these clones are making tons of money. And they can afford to hire big name firms and really smart partners who are going to go in there and really attack the basis for the ownership of the underlying IP.
Right, and so the judge determined that a number of these questions should be decided by a jury. Everybody was excited about seeing how this was going to play out, and then the case recently settled, as most of them do. People get excited about these cases, and we find that generally they do settle. But if from your guys' perspective as advising your internal clients, what are the takeaways that you want to be looking at? I mean, do you kind of have this tension between not appearing to wield a hammer over your fans, to encourage the community to develop things, to recognize that you are building off of what other people have done and that other people are going to build off of what you've done. But there's really cultural issues involved, right? In terms of whether you pull the trigger on one of these lawsuits, and how do you make those decisions?
I think on the development side, it's pretty easy. I mean, educating people as to what, don't steal other people's expressions is a pretty easy message to communicate internally.
Well, except that nobody really knows where the line is, though, right, between
Sure, and you have to constantly train people and, basically show them these cases and talk about what are the idea-expression dichotomy. And for us, it's particularly relevant because we're a popular game. And so anytime we're creating new content, there's at least a dozen people who have already thought of the idea, right? If we're going to make a new skin for any one of our characters, it is impossible for us to create something entirely original because there's some fan out there who has already created it, in some variation. And so invariably, we get people pissed off, emailing us, sending in a player support ticket saying, you guys stole my idea. I had this idea, 12 months ago, and I, put it on some board, and you guys stole it. You should compensate me. Happens all the time. Right. And so educating people on not only like how do you respond nicely to someone like that and let them know that, no, we didn't steal your idea. And by the way, 20 other people also had the same idea. That's part of it, is the education and training, not only internally, but also messaging people outside so that people don't feel bad when they realize their ideas aren't all that original.
Right.
And then on the other side, on the enforcement side, you don't want to be hypocritical. Like, you don't want to be going and enforcing something where your IP isn't particularly strong. Every IP is going to have parts of it which are really original. We have the expression is really, really great, and parts of it which are not so great. And I think that's what's interesting about the next case that we're going to talk about, the PUBG case, where you can try to have an argument about where is the real original expression for the PUBG game, and what is sort of on the other end of the spectrum, closer to the unprotectable stuff, the stock stuff, standard stuff.
But I mean, what I find interesting is that you have had quote unquote copycat games for forever, going back to Pong, right? And Bill, I don't know if you want to weigh in on this, but how do you decide, as legal counsel for a gaming company, when do you kind of see imitation as a form of flattery or as part of the necessary creative process, and when do you say, you know what, I'm going to instruct my outside counsel to file a lawsuit?
I'm not sure I ever really considered a form of flattery, the type of imitation that we're seeing. But I do think that you have to weigh the costs and the impact to the players. It's kind of like playing a game of whack-a-mole at this point, so you can't go after everyone all the time. You just have to really analyze, whether it is confusing for players where the source of this game is coming from. If it looks so similar that people are thinking that we're putting it out, then that's a big problem, and something that we would want to remedy. Or if it is something that is, really taking market share in a way that is abusing our IP, then that's something that we would look at too. But it is a cost-benefit analysis.
Yeah.
Going back to the point of like the lessons from this case, I would say one of the other internal things is other developers have games that really do rely on user-generated content a lot more than we do. So for them, you really have to be careful about when you have these modding tools that you give out or are very reliant on user-generated content, think like a Minecraft or a game like that, about how you reincorporate that back into your game, what kind of rights you're giving to people who are creating user-generated content, because there's a tension there. If you are too heavy-handed, then people aren't going to want to participate and contribute, but without being clear about ownership, then you get into these very murky issues.
Right, right. No, it is. It's definitely something where perhaps much more so than other industries, you need to be very attuned to what your fan base is thinking about your actions from a legal perspective, because I think that people just culturally are going to view it differently than if it's even say a Nike or a Coach or Chanel or other companies that are big on enforcing their IP. I think that there's just a different mindset around the creative process and the role that fans play in these games. So let's talk a little bit about the copycat stuff. So this really does, it kind of goes in fits and starts, and there's periods where you see lots of copycat games that nobody brings lawsuits over. Sometimes they do, and it's been a kind of a mixed bag in terms of how plaintiffs have done. Years ago, probably a lot of you weren't even born at the time that Donkey Kong and Pac-Man came out, but the couple of cases from the 80s, there was a lawsuit involving Nintendo and Universal over Donkey Kong. They were alleging, Universal was alleging that it was an infringement of King Kong. And interestingly, going back to Lilith, one of the arguments was you don't even own King Kong. On the other side was a case involving Atari's Pac-Man version, which was an interesting case because this was a really hotly anticipated title for, I think it was the Atari 5200 at the time.
You said it, I wasn't born.
Yeah, right. But in any event, the Coleco, or not Coleco, it was Odyssey came out with a copycat game called Casey Munchkin, which ultimately was enjoined because the court found that its efforts to create some dissimilarities with Pac-Man were not sufficient. So they had 3 monsters instead of 4, and the chomping character had antenna, and that was not enough. For I guess a few years ago, you had the Tetris case involving Mino, which was essentially a Tetris for iPhones that was found to cross that idea expression line. But we really saw it heat up earlier this year with the renewed interest in Battle Royale games. So you want to talk a little bit?
Yeah, so I'm going to show some pictures here because I think this is actually the fun part, is we treat this like a little game. I'm actually going to stand up for a second so I can even see what I'm looking at a little better. Whoops, that's the wrong way. All right, so we're going to look at 2 different games. I don't know if everyone can see real well, but on the right, you have PlayerUnknown's Battlegrounds, which is a Battle Royale game which is very, very popular. More people in here have probably heard of Fortnite, which is simply a less fun version of PUBG. I'm just kidding. But they're very different. Fortnite's more cartoonish. It's more popular in the West. PUBG is way more popular in Asia. I think that's still true. Yeah. Maybe. And so, they're basically the same idea. There's some minor differences in Fortnite. You can build buildings and structures and things like that. But, you come out of this airplane, you parachute down, there's like 100 people, and it's basically the Hunger Games where you try to, be the last person standing, and there's these, giant circles that sort of make the play area smaller and smaller. Pretty simple. On the left, you have a copycat game published by NetEase called Rules of Survival. And we're going to look at some side-by-sides. And as we go through these, try to think to yourself, not only from a legal perspective, do I think this is copyright infringement, but also from a fairness perspective, do I think this is too far? So on the left, you can see sort of the staging area, which is before the game starts. You have a minute or 2 of just sort of sitting around, doing very menial things. Then you get to the airplane stage, even the sequence of how the gameplay proceeds is identical. And the airplane is flying over the island at a different trajectory each time, so you don't know exactly where it's going to go. You jump out. You can see the 3rd slide down. That's the parachute phase. And then these crates down at the bottom, you can see on the bottom right, there's like a red crate with a blue covering. Well, Rules of Survival has a red crate with a green covering, right? So that's how they sort of distinguished it. Whoops. Okay, so now we have, and this is these are images taken out of the complaint that PUBG filed against NetEase. And so they're trying to say, you guys have a big grassy field, we have a big grassy field. You guys have a shooting range, we have a shooting range. You have a rural aqueduct, we have a rural aqueduct. For me, this is when I start to go, okay. So even if, and this gets to the sort of the really interesting question for me, is even if you look at all of these images and you conclude that no 2 of them together are that similar. In other words, NetEase didn't take the protected original expression of the PUBG company because maybe their aqueduct, looks different, but it's still an aqueduct. Does the sort of collection of all of these things in the aggregate, in other words, if I don't have copyright protection over the depiction of an aqueduct, but the aqueduct plus the field plus everything else, is that sufficient to give me copyright protection? So that's the other interesting question as we're going through this. Shipping containers. your game has shipping containers, our game has shipping containers, right? But they look different. Right? These are blue shipping containers. There's a farm area. One has a tractor. Look at the two-story home, right? So like the two-story home, different colors. I wish I knew more about windows to know, like, is this like the same style of window or whatever? But you can analyze, the details of each of these things to try to say, is this different enough? One's got brick, one doesn't. But in terms of like the sort of big opening for the garage area or that whatever that first open area is on the, the first floor, then you've got the garage roof deck on top of the two-story house, also basically identical. You can see that there's some slightly different variations in how they moved it, but they didn't change it very much. Three-story residential building, roof deck on the three-story residential building with the railing, single-story buildings with the railing, observation towers in both games, both realistic. And then they start talking about the weapons. This starts then to get interesting, and you start asking, well, how far can you go with this? You didn't invent the Tommy gun, right? And muzzle attachments for the guns, they're all the same. Of course, these are realistic weapons. And now you see where they're really reaching, right? The energy drink in Battlegrounds. Is that PUBG's original expression? I mean, I'm sure a lot of you look at that immediately and you go, wait, isn't that like Red Bull, right? I don't know if it's called Hot Bull or whatever they call it. But yeah, and so actually in response to stuff like this, it wasn't this specific example. Let's see if we have it actually. Frying pan, which serves as armor for the posterior.
I think this is a good example. I mean, a lot of the stuff that you talked about, once you decide to have a third-person shooter that involves people being thrown out of a plane, and fighting, you're going to have certain things that are going to be necessarily found in those games. You're going to have those weapons. This is one that you wouldn't immediately think is necessary. The frying pan.
Which is true, although the point that NetEase has made was PUBG was not the first game company to make the the game with the butt armor.
And what's even more interesting about it is so there has been a motion to dismiss pending for I don't know how long, like many months. But just last week there was a motion by NetEase to stay the determination of that motion pending a Rule 11 motion that NetEase wants to bring, and the basis for that is that apparently a lot of the weaponry and some of the other images were not actually created by PUBG, but were actually obtained from what are essentially stock clearinghouses. And so to the extent that they are relying upon elements that they didn't create and don't own, they're saying that you're trying to pull a fast one over on the court. Now, I think in response, the response is going to be essentially, well, we're not saying that we own this stuff. We're saying that, again, this combination of the elements is really what we're trying to protect. I'm not sure the complaint actually reads that way, but this really kind of becomes front and center, and you're seeing this in other areas. The recent Stairway to Heaven case, when the Ninth Circuit reversed and held that the jury was instructed improperly and remanded for a new trial, there was an issue in there about the combination of what are by themselves unprotectable elements there, musical notes, and it's really something that courts have struggled with, and it's almost impossible, frankly, for a jury, I mean, even a lawyer, to really draw that line in any consistent way across cases. And I think it tends to be pretty outcome determinative. That you're going to look and you're going to say, well, I kind of Potter Stewart, I know it when I see it, right? And then how do I then justify that reasoning by saying this is expression as opposed to ideas, and or this combination is sufficiently numerous enough that it's crossed the line.
Yeah, I'm certainly the same way. I mean, when I take off my lawyer analytical hat, once they took the aqueduct, I said, my fairness sort of, instinct said that's ridiculous. You didn't need to put an aqueduct in there.
Right, but the first thing that I look at when I look at it, as you say, is Fortnite, and then you say, okay, well, why aren't they going after Epic Games?
Yeah. So, and of course, and actually, you should probably talk about this one a little bit with the the licensing stuff and.
Yeah, I mean, one of the interesting things between PUBG and Fortnite is that PUBG was built on the engine the Epic engine that Fortnite is created by Epic, so that the company that they're licensing their engine from is in direct competition with them. Fortnite's Battle Royale mode came out after PUBG, and so there has been some issue between those two parties because PUBG seems to feel that because they're using Epic's engine, Epic is privy to some of the confidential information about how they made PUBG, and therefore are unfairly competing with them.
So there was a lawsuit, right? And it was filed in Korea. Interestingly, I think number one, it's really a home field advantage issue for Bluehole, right? And then you also have the fact that the law is different, and it, as I understand it, Korean law could protect this kind of more amorphous notion of unfair competition that the Copyright Act here doesn't. You have these strict rules on idea expression. I think most commentators have recognized that under US law, there would be no case against Fortnite. But what was interesting is that this case that was filed, right, was kind of dropped quietly. Any thoughts on why that might have been?
I wonder if it wasn't just a PR thing to let the gamers in Korea know kind of how they felt and what the situation was, that it was unfair, and to try to sort of draw public sentiment to this, even knowing that they didn't really have a good case. Either that, or they were just so angry in the beginning they wanted to sue, and then sort of realized later that they didn't have the greatest case, and there really wasn't anything they could do about it. Mm-hmm. But we've seen the same thing in China as well, where you have these unfair competition claims which are asserted together with the copyright claim. Mm-hmm. But I've seen them more successful in those jurisdictions where there's also allegations about workers leaving one company to go to the other company and either taking something with them, right, or there's some sort of foul play separate and apart from just copying the game itself.
Right. So if we have time, we can circle back to this in the questions, but I want to make sure that we get in the gambling discussion. So lots of developments over even this year. Really, I think starting with the Supreme Court's case in Murphy versus NCAA, court struck down the Professional and Amateur Sports Protection Act as unconstitutional. That prohibited most sports betting. Now, there has been a perception that this somehow signaled that sports betting is legal. It didn't really do that, though, right? Right, Bill?
Right. So the PASPA, the Professional Amateur Sports Protection Act, really only prohibited states from licensing gambling, except for Nevada and New Jersey, if they had actually enacted it within a couple legislation to allow sports betting within a couple of years of PASPA's enactment. So really what the Supreme Court did is make it legal for states to enact regulations to allow sports betting. And a number of states have started that process. New Jersey probably going to be the first, but I don't think any of them have actually completed that yet. So it will be up to states, state-by-state analysis to determine, a state-by-state decision whether they want to allow sports betting, and then they'll have to enact the rules to allow it.
And then I think one of the interesting questions is going to be, how do you then limit that to the residents of that state? Because one of the other kind of limitations on this ruling is that they are essentially saying, look, so long as it's intrastate, the states can regulate it and decide whether they're going to make it legal Once you start dealing with interstate gambling, then it would be in violation of the federal laws, right?
Yes, and so there's a couple ways that interstate gambling is going to be problematic. The first is that, currently it's illegal in Nevada, but any kind of licensing in Nevada, they require, geo blocking. They have to make sure that people are only within the state. So any kind of state that licenses sports gambling would probably make those requirements as well. But there's also another statute, the Unlawful Internet Gambling Enforcement Act.
They need catchier names for these.
UGA. And basically what that does is, Congress realized that, I think it was in probably the late 90s or early 2000s, there were all these internet betting sites that were setting up offshore, and people were betting off, on these online sites that were set up offshore. And so they had no ability to regulate those. What they did is they passed this UIGEA Act, which basically prohibited financial institutions from participating or facilitating transactions. If somebody was trying to make a bet from California into Nevada, for example, the financial institution would be on the hook if they allowed that transaction. So basically that killed the market for offshore betting. One interesting development is that, at least as it relates to esports betting, is that an organization called Unicorn recently got licensed in the Isle of Man to provide sports betting, and they use cryptocurrency, partially I think as a way to be able to allow people to get money into the system without running afoul, without financial institutions being able to determine they run afoul of the UIGEA. Mm-hmm. So we might see a resurgence in these offshore betting organizations that are reliant on cryptocurrency to kind of obscure that.
Right, and I think that obviously the Supreme Court opinion dealt with sports betting, but this all is relevant to the video game industry for really, I think, at least two reasons. First of all, you have a number of games that are themselves gambling simulations, and we talk about the Cater Churchill Downs case, but then also you have a number of issues that arise where there is gambling either on or within potentially a game. And so just to kind of tick off what some of those are, and then we'll get into them, there's the issue of loot boxes, which are essentially blind. You pay virtual currency and you might get a really rare skin or some special power, but more often than not, it's going to be kind of worthless. It's like when you had a pack of baseball cards, and maybe you would get the Ken Griffey Jr. rookie card, but most of the time you'd get the 5-cent commons, right? And is that gambling? And a lot of countries have stepped in to regulate that. I think primarily based upon psychological studies that show that it triggers the same receptors in kids' brains as it does when adults are playing roulette. So you have that, and then you have also these kind of secondary market betting, whether it's items that are won within a game are then turned into real cash on a secondary market or gambled on third-party websites. So what are some of the issues that you're interested in with respect to this?
I mean, I think the loot box issue is a big one that's facing the video game industry now. And the problem is that gambling is regulated in the United States state by state. So there are different statutes in every state as to what constitutes gambling. And now, on top of that, we're getting regulations on loot boxes that vary by country, country by country. And so with this kind of patchwork of regulation, it's hard to know what you're able to provide and if you have to start blocking off certain regions. And I think that, as different monetization strategies come up, as the nature of gaming is evolving more to mobile and there's different, microtransactions that are becoming more popular, those kinds of monetization strategies might start bumping into gambling questions as well.
So I think where a lot of the action is on these cases, so gambling, just to kind of back up for a little bit, it's defined differently, at least somewhat differently by different states, but generally it's staking or risking something of value upon the outcome of a contest of chance or a future contingent event. It's not within a person's control. Upon an agreement or understanding that the person or someone else will receive something of value. And where I think a lot of the action is what is valuable? So both with respect to, are you staking or risking something of value, and are you getting something of value? And so, for example, if a player uses virtual currency for a chance to win a virtual item that can't be cashed out of the game, is that something of value?
Well, in the past, I would say no, but after Churchill Downs, the question, it could be. If that thing, for example, could be exchanged and then you could play more, then I think the Churchill Downs case...
Do you want to talk a little bit about that case?
Sure. So in Churchill Downs, we're dealing with a basically virtual casino. It wasn't a game of its own that had gaming elements in it. It was your traditional casino type setup. People could put money in, they could get chips, and then they could play in this virtual casino. And Cater, the plaintiff, had challenged, after losing a fair bit of money, had challenged under a Washington statute that this was illegal gambling and that she should be allowed to recover her funds. And there, the court took a look at whether or not what she was either getting out or putting in was actually a thing of value. And even though there was not necessarily a secondary market, or at least the court didn't really focus on whether there was a secondary market, the simple fact that the chips that she was potentially winning would allow her to play more of the game was a thing of value under the Washington statute.
But see, now, where I, when I kind of look at this from the outside, I'm saying, well, how is that different than any of these other freemium games where in order to get extra lives, you need to pay real money? And I mean, that's essentially how games like Candy Crush have, been so successful.
I think that's a good question. I'd ask the Ninth Circuit what they think about those as well.
Mm-hmm. Yeah, the other thing that I would add that I think is really interesting, adding to the uncertainty of when we think about what has value, and we were just talking about this yesterday, there's all these different areas in the law which are starting to talk about virtual property and virtual content and whether it has value. So outside the traditional four walls of gambling, for example, Brian Berman was telling me about the estate planning law in the state of California, where now if someone dies and they have virtual content in a game account, they can essentially, bequeath that to whoever they want. And if the terms of use basically prohibit it or say it has no value, the terms of use are invalid, and that doesn't matter. And so you have this state law saying, well, this does have some sort of value, and you do have to be able to transfer it upon death. So that's one area of our sort of legal framework where there's an argument that something has value, maybe. Then you have the uniform virtual currency law, which I'm not even sure how many states have enacted yet because it's very, very new. And that talks about what is currency and how is that going to be regulated. And it has a specific exemption for virtual game currency, but there are contours to it. It has to be sort of only used within the game ecosystem by that one publisher. And so is it convertible, non-convertible, those sort of questions? And then we have the state-by-state sort of framework as well that we all have to think about, like what is value.
Now does the fact that you wouldn't want, as a gaming company, it to be determined to be gambling, does that kind of mean that you should be policing the secondary market and making sure that there's no out-of-game transactions or buying and selling of this virtual property, and how much of an eye do you need to keep on that? What is your obligation in terms of looking out for that stuff?
I mean, I think if you are allowing a secondary market to exist, then you are definitely raising the stakes that it is something of value, or that it will be found to be something of value. I think like Valve in the CSGO case, so Valve had this game where you were able to trade skins, and people were betting on these skins on secondary sites, not authorized by Valve, but the Washington Gambling Commission basically held them to task because they authorized this ability to transfer items. And really, it was because of this capability that they allowed for that Valve was being held responsible for the gambling that was going on, or the betting on these items that was going on. So eventually, Valve shut off that transfer feature, but there is a certain level of responsibility that comes from enabling that kind of ecosystem to exist. It's much safer to have a closed ecosystem.
And I was just going to say, the same is true when you think about the loot box problem. Bill alluded to it earlier when he said there's different monetization strategies, but part of why we're seeing all this attempt at regulation is because we've had one or maybe two very aggressive monetization techniques. And someone also made a comment the other day that the industry actually takes care of itself pretty well, and we don't really need that regulation. At least that's one argument, because gamers hate it, and they realize that is a cash grab sort of feeling, that people don't want to play those games.
But I mean, it's been around for at least 10 years, so obviously it's making people money, right?
Well, I'm speaking specifically about the loot box practices, which I'm not going to name the company. Where it really felt like gambling, and you had to use that mechanic to even play the game to progress. It was very, very aggressive, and that's now causing this. But to tie it back to Bill's point, you have to be thinking from a game development perspective, how do we responsibly design a game, whether, to think about that framework in mind, not just from a legal perspective, but what is the right thing to do by your players?
The other thing that I think I'm curious about from kind of the perspective of in-house lawyers at a gaming company, and this is where I think you tie things in with the Supreme Court case. In addition to sports betting, there is a market for betting on esports. And the same way that you can bet on the outcome of a football game, you can bet on the outcome of a League of Legends game, or and so is there an obligation to try to police that, whether legally or morally, and if so, how are you dealing with that issue?
I think it depends on the nature of your game whether you do want to police that. I think that there are certain types of games where maybe you want the gambling association. Example I give is FIFA. A lot of people play FIFA. In the world of soccer, football, having gambling and affiliation with gambling is pretty common. I think it's something like 60% of the top 2-tier leagues in England are sponsored directly by gambling sites or betting organizations. It's something that's expected. It's kind of normal. And you might have a slightly older population of people playing a game like FIFA. So maybe if they wanted to develop a sports league, they would want to be affiliated with that. It would make it feel like you're playing, you're managing a team just like any English Premier League team. And thoughts on gambling vary in countries too. I mean, it's very normal. It's very accepted in England, but in other countries, it's completely forbidden. So I think it really depends on your market and your audience. I think that if you have a game that skews younger, then you do need to be careful because you don't want to be encouraging minors to gamble.
I can only watch soccer if I have money on it. So so I'm told that we just have a few minutes left. So I'd love to open it up to questions in the remaining time, if anybody has any. Way in the back.
So you were indicating that it's an issue to be able to buy and sell skins or other things in the game. And so how do you deal with WAPs or companies like that where they're creating marketplaces that essentially allow for out-of-game transactions?
A company like what? I'm sorry, I couldn't hear the. I think that if you allow for virtual items to be traded, it's not necessarily in and itself a problem. It just raises the issue that it could be seen more as a number of different issues. But like, for example, if you're giving skins away in some sort of random way, that's going to be gambling. If it was a completely closed ecosystem, you have a better chance at that not being considered gambling because does this thing have, this virtual thing have value? But once you can transfer it out and put a price to it for somebody else to buy, and you're allowing that to happen, then you open yourself up to that. So if you didn't have any kind of, skill-based way to get some of those items, then maybe you don't have any issues by having that kind of secondary market. But if you do, then you really need to think about that.
I think as a practical matter, it also, you usually know when something gets big enough where you can see this looks like gambling. I mean, I don't think gambling is that hard to spot. And I think when you see, based on what your game is and what conduct is occurring, once it gets to a certain level, if it looks like gambling, as Valve discovered with their issue, they decided they needed to shut that down. So.
Other questions? Yes.
First, congratulations on offering in a nutshell. You're thinking law school, you guys are offering a nutshell. I'm curious the relationship, the comparison between traditional gambling or actual money where it's all regulated, and we all know there's Gamblers Anonymous, and so there are people that can't control themselves. Is it similar? Is the percentage similar, or is it hard to tell? Does it no one take a look at that? Because you mentioned the moral responsibility of keeping your control of this as opposed to illegal.
My wife spends about $100 a month on Candy Crush. I think that would probably qualify, right? What do you guys think?
I mean, I think it's similar to the comment I made before. If you look at the game you have and you look at the conduct that is occurring, I do believe that it is not that difficult to really say that smells like gambling to me. And I think even very responsible developers can get people on the e-commerce teams and people who want to make money. They say, we want to do this, and usually if it's gambling, and it feels bad and it feels like it's touching some of those trigger points, you're going to start to see that, and then responsible companies, I think, have the duty to do what's right. And I think also players. I think there's also good business sense. Yes, you can make a lot of money in the short term by making games and making those sort of cash grabs, but in the long term, I think it does a lot of harm, and it doesn't make good business sense to really alienate players and treat them badly and abuse them in that way.
And even gaming companies that don't have gambling or gambling-like mechanics will occasionally cap companies that have an ability to enter real currency into the virtual currency will have caps or something that you can only put so much in a certain period of time, even if there isn't really a gambling mechanism at play, but just to make sure people aren't overdoing it. So I see that often in a number of different companies, they do that. And
there is actually, so there's legal, on that specific point, the FTC has taken action against, I don't remember if it was Amazon or Apple or both, on that specific issue of protecting children.
Yeah,
right,
they were looking under, and COPPA, they were looking under at a lot of big companies. I don't know if they actually took action, but they were definitely issuing subpoenas and...
well, and they did sue Amazon. I remember it was a kids game. There were in-app purchases, and the parents were not aware. It wasn't sufficiently clear to the parents that the kids could just keep clicking, buy more acorns, or buy more apples, right?
Now, when you're spending, $1,000 on hay for your fake horse, I think people are going to be, I don't know, I'd be upset. Okay, I think we have one. Okay, any other questions? I'd like to know if that picture's the last time you wore a tie. Is that right?
It may have been.
It probably was. All right, guys, thank you.
So we'll be starting the panel in just a minute. I'll return. Thank you. Okay, great. Great. Well, thank you all. My name is Oral Kagler. I'm with the California Institute of Technology and a proud LAIPLA member and Loyola graduate. It is my great pleasure to introduce our final panel for today. Afterward, we will have a reception with drinks and appetizers, so please stay for that. Anyway, I am welcome to our panel entitled Blockchain, the New Frontier Comes to Media and Entertainment. To discuss this transformative technology, well, I'll have to start, of course, with Jeffery Atik is a professor of law and Jacob Becker Fellow at Loyola Law School. He regularly teaches and writes on fintech, smart contract, and blockchain law. We also have Cameron Casey. He's the co-founder and chief creative officer of SmartChain Media, a fan-based media company harnessing blockchain technology to democratize the entertainment industry. We also have Dr. Nelson Granados, who is the executive director of the Institute for Entertainment, Sports, Media, and Culture, and director of the Center for Applied Research at Pepperdine's Graziadio Business School. We also have Nguyen. He's vice president, special projects at Sagewise, a company working to build a platform that provides a safety net for smart contracts, governance, and transactional confidence into the blockchain. And walking up dramatically is my friend David Randall, a shareholder with Brooks Kushman in Los Angeles. David represents clients in complex IP litigation matters and has prosecuted hundreds of patent applications, including having experience with blockchain. So please welcome our panel. David, I'll hand it over to you.
So the theme today has been about disruptive technologies, and so certainly blockchain has been touted as a technology that has the potential to disrupt a number of industries, or at least transform them and make them more efficient. And so I think one of the things that, you know, we've heard a lot of hype about blockchain and different cryptocurrencies, but before we get started, why don't everybody tell me if they have invested in blockchain technologies, either through cryptocurrencies or some other way? Have you? So we have a few. Has anybody invested in more than Bitcoin? Okay. So for me personally, my aha moment came about a year ago. I was listening to a VC named William Quigley. And William basically made the point during his presentation that he will never invest in equity again, that he is only going to invest in companies through ICOs. And here's a man that basically ran Idea Labs out of Pasadena and ran a $700 million internet fund. And so he was saying that he is never going to invest the traditional way in a company again. And as an IP lawyer who essentially relies on equity investments in a lot of startups and stuff, I decided that I needed to learn something about this technology. And so I needed to learn something quickly. And so I started to investigate it, and to me, it became pretty apparent quickly that while there's a lot of hype around the cryptocurrencies, and in fact, at that time, cryptocurrencies were worth about $800 billion, almost $1 trillion, and now they're down to $200 billion, that the underlying technology itself had a lot of potential. And for example, right now there's about 4 billion cell phones in the world, smartphones, maybe 5 billion. Whereas by 2024, there will be 65 billion connected devices on the Internet of Things. And for the Internet of Things to really work, you have to have shared databases. And one technology that's going to enable that shared database, and so that everybody's working off of the same data, and that the data is trustworthy, is blockchain. What about you, Nelson? What was your kind of aha moment?
Yeah, so mine was pretty nerdy, actually. I did my dissertation on transparency in electronic markets back in the early 2000s, and So I've always been tracking this notion that the digital world is creating new phenomena regarding how transparent markets are or can be. When I did my dissertation, I did it around, I borrowed the concept of transparency from financial markets. And so along comes blockchain, and one of the first terms you see when you hear about the potential for blockchain is that it can make markets and business transactions more transparent. So that was my aha moment. And then at exploring it, I think it has huge potential in the sense that it can enable transparency and decentralization of power in business relationship, but also it enables selective transparency, so your ability for some parties to see some things, other parties to see others, and that may be very beneficial in different types of markets, which is sort of what I love, is studying how technology changes the economics of markets.
What about you, Professor Atik?
Well, I've been interested in financial technology generally, and international payments was the thing that got me looking at the blockchain at the beginning. And when you first hear about it, it's incredibly bizarre. You hear about miners solving strange mathematical puzzles and this mysterious stuff that floats through the air and that's everywhere and nowhere and escapes any kind of regulatory power. But when you study the invention and get a sense of how the various parts fit so elegantly together, it really is a thing of beauty. It's not just its wonderful technological possibilities and new applications that inevitably will be discovered, but it's really a remarkable invention because it is technological, but at the core it's also very human. And part of the brilliance of it is it creates incentive systems for people to act in new ways and to coordinate in new ways, which again opens up some fantastic possibilities.
Cameron?
Yeah, so my first experience with blockchain, when I was working with my partner Alex, he and I had common goals of transforming the entertainment industry. And he and I, I've been in the entertainment industry for about 30 years. I have, produced, 6 films, and I've, produced television, and I've done commercials. I've kind of done the gamut in entertainment. So I brought a skill set to the team, and we started talking about how technology can just transform the industry. And we both had a similar passion, and we created a company called SmartChain Media. So the idea behind SmartChain Media is that we want to democratize the whole industry. And what I mean by that is, right now, obviously, what we know of the entertainment industry is the studio system. We know now things are moving into platforms like Netflix, things like that, which are very much push models. They're pushing it out to the consumer. They're raising money. They're creating movies and TV and entertainment, and they're pushing it out to audiences, hoping that audiences will pick it up and buy it. And what we're doing now with our technology is we're creating basically a pull model where we create a fan base globally prior to anything being made. So we'll curate fans across the globe for projects, for any type of entertainment that they are passionate about. So there's kind of 3 phases of SmartChain. Phase 1 is development, where you create fans, you bring them together with creators, and they can create these projects and create a groundswell before they get produced. So nothing will get produced until there's a community based and built around the particular IP.
So basically, until you already know somebody's prepared to consume the content.
There's a global fan base before the project goes into production. The second phase is production. There we are basically curating producers and production companies and resources all over the globe to partake in that production. So the stage 2 is interesting because all brands can also get involved at that stage as well. So, and then stage 3 is the banking back end and the distribution back end. And we currently have processing in 168 countries. So we are a global company now. Our technology is very robust, and so we're going to expand this thing very quickly. So there's as a sort of blockchain incubator, so to speak, there's a lot of potential for creating these really interesting models around the different phases of entertainment to one, create a transparent model that people feel comfortable with and trust. There's also security. There's accountability. And then there's equality, because obviously what ends up happening in the model today is the people who really lose in the business model that's built today are the creators. The fans ultimately lose as well, because if the creators are losing, and I mean losing from a creative standpoint, they lose from a financial standpoint, they lose from a spiritual standpoint. I mean, it's pretty horrible what happens to creators in the industry. And ultimately what ends up happening is fans end up missing out too. I don't know how many people have, tried to produce a movie or sell a movie or had clients try to sell a movie. It's a very difficult situation to tackle. And it's actually demoralizing, actually. And so what we're trying to do is sort of give the power back to the fans and back to the creators. And I think with blockchain we can do that very effectively, and we're really excited about it. So
we'll talk a little bit more about your project later on in the presentation. Dat, why don't you tell us about your aha moment?
Yeah, so my entrance or my interest in blockchain started much differently. I was actually a patent litigator at a big firm for about 7 years. During that time, I'd started several small businesses. I was a little bit tired. I think I enjoyed the practice, but I think that once you really work in law for a while, you come to realize that law doesn't really serve anybody. Our current legal systems are bloated, inefficient. They don't even serve the corporations that can afford to pay them, let alone the small businesses that need to use them. I've had some ups and downs with some of my businesses. Some of them are successful, one of them not, and that led me to this lesson. And the lesson was that we had a dispute, disagreement between partners. And what happened was one of my partners ran into the bank and just emptied out the bank account. And I went to the bank and I was like, "What are you doing?" Clearly all of our names are there. You can't just simply allow somebody to drain a bank account like that. And so, long story short, that was lost, and I realized there was a problem here, a big problem that needed to be served, and I didn't think anything about blockchain at the time, but as I did my investigations, I explored arbitrations, other ways of kind of banking, without having to trust a bank. I've gone through nearly every major bank. The best one is Chase, and they're the only ones that even ask for a corporate structure. But even then, anybody can come in and drain an account if you have your name on it. So when I discovered blockchain and kind of cryptocurrencies, not this current iteration, which is more or less a speculative market, but what it should be is really a currency, and a currency that allows the users to program their money. That's what really excites me, which takes the control of money away from others and leaves it to those who hold that asset. And so now ultimately the goal is that you can have what they call a distributed autonomous organization, a DAO, where you program your entire LLC structure, and that's governed by code, that's governed by rights, so no single party can just come in there and empty out an account. They have to be voted for and approved like any LLC, but now this is enforced by code. So that's really exciting for me. And then the other back end of that is once you have this virtual jurisdiction, essentially, you actually also can bring in new legal structures, not ruled by any sovereign nation, but you can kind of get into cross-border trade. One thing I discovered was that in my consultation and my investigations was that cross-border trade, a lot of times the disputes never get resolved. Something about like half of this disputes just kind of, you just eat the loss because it's just inefficient to do so. But hopefully in the near future, once we have some sort of larger blockchain or cryptocurrency that is accepted by most parties, then cross-border trade can be done on that. And then we'll have reputation systems, and we'll have sort of a guild-like structure wherein people have to buy in, and if they're a bad actor, they'll get kicked out and they'll no longer be able to do business there. And so that incentivizes people to act accordingly, filling in the gaps where government could never do so.
So certainly, as we progress today, feel free to ask questions real time. You don't have to wait till the end of the discussion. So, please, Carl.
Can I take you up on your offer?
Yes.
Interrupt and ask questions?
Yes.
I just wanted to get some further clarification from that.
Sure.
And you seem to say two things that could reconcile. One is that a lot of what you're doing is being built into the code. So in other words, code rules. And then on the other hand, you said it will not replace government. So, I mean, it seems to me that as government, using that term very loosely or very largely actually, defaults in certain regulatory environments, that code fills in and essentially provides the default rules for resolution of disputes.
So no, sorry. Let me clarify. So what I mean to say is that code is would serve as the initial gatekeeper, because let's say you're going to go to your bank and the teller doesn't really know anything about your business. The teller is generally not terribly sophisticated, and so with enough pushing and pounding, the teller will generally capitulate, or maybe not, right? You really don't want somebody like that managing or being the gatekeeper to your funds. And so the code would be the initial gatekeeper. Now, on the back end, when there's a failure of the code or some misunderstanding with respect to the smart contract or your regular contract there, you'll still have a virtual or digital jurisdiction that is managed by arbitration and traditional, kind of quasi-traditional legal structures that will serve to kind of fill in the gaps. Does that make sense? I don't believe code is law. Code is code and law is law. That's why there's two different words. As a patent attorney, there's a reason we have words, and that's why they're different.
West Coast law versus East Coast law. West Coast law being code that essentially sets the overall environment for resolution of disputes, for substitute regulatory.
Sure. If we take the notion that code is law to be true, then we're gonna cryptocurrency will never take off. Last year alone, over $1 billion of financial, assets or wealth was lost due to code being law, quote unquote, right? That's smart contract vulnerabilities, failures, failures of hacks and other things like that. And if you're gonna say code is law, well then that's it. The person who lost that money really is kind of out of luck, right? And that's just no way to do business or to bring any adoption on any platform. You're way worse off on blockchain or in an ecosystem where code is law than you would be in the normal space.
So why don't we talk a little bit about what value the blockchain provides? And so Nelson, why don't you?
Yeah. So just a little bit on my background. I'm not a lawyer. I'm a technologist. So I'm just going to go from that angle, and you guys help me from the legal side. All the others here. So I like this first slide because for those of you who are not techies, really to me what is important to understand about the potential value is how does it provide value incrementally over technologies that already exist today. So the sentence you see there, you see the value relies in the fact that it provides you the ability to record and distribute a single immutable version of the truth to multiple parties. And the reason I like this sentence, take the bolded words from that sentence, and that's what we can do today without blockchain. Record and distribute a version of the truth to multiple parties. So the big difference is single and immutable. And so the idea there is if multiple parties in business transactions can have the same version of the truth, that's a huge advantage versus everybody having their own little siloed version of the truth, which maybe, it could be wrong, it could be outdated, somebody may be cheating on the other end, they'll tell you this is the record, but really this is the record, right? So if you're able to have a common version of the truth, that's actually, it brings the transparency aspect that I alluded to earlier. It allows traceability because we can all see what the record of the past is. And then also because we all have, to a certain extent, a more equal level playing field in terms of the amount of information, then the different parties share authority, power, which actually can bring efficiency to markets, and especially to electronic markets. So to me, that's where the underlying value relies for the future of blockchain is around this area. And then if you add on top of that, you
want me to go back or?
No, that's perfect, actually. Good segue. So thinking about it in terms, again, a little bit technological here, think about the traditional way of ensuring a single version of the truth today is to have a centralized database, right? So in your organization, you have one database, that's your version of the truth. Hopefully there's one and not several, but usually there's several, right? But the blueprint is to have one central database. So that's how you do it. And then, you know, it all obviously has its pros and cons. One of the cons is it's hackable, and if it's hackable, you know, you hit that big database, and you know there'll be trouble, right? So then put on the contrast what you see here on the other side, which is the distributed version, where, you know, so without that centralized database, then everybody can have their own, right? So you see on the left-hand side, you see everybody has their own. And that's the problem of that is they're not synced. They're not in sync, right? For different reasons, they may not be in sync. But what if, and then those yellow lines show, what if they were all to be in sync? Then that would be a great thing. So for example, for media entertainment, if you have creators, financiers, and producers with the same version of the truth, right, then they can transact faster, there's less friction, the deals can go faster because everybody has the same data to work from, the same contracts to work from, right? Then what if you add now distributors? Then money coming in from the distribution side can be based on the contracts that have been set and the deals that have been made. The money coming in can be allocated correctly across all the different players in the creative side and the financing side. And then if you add consumers, right, so you close the loop where even consumers come into the picture through a content delivery system, then by tracking consumption, then again, that can trickle up the value chain so that everybody gets what they deserve based on the deals and contracts that they have made. So that's where the potential lies.
And while you have it here, distributors, creatives, financiers, in reality it could be for different markets, those could be different stakeholders.
Could be anything, yeah. You know, it's an interesting thing in this context, in this setting to remark. This distributed technology, P2P technology, was the exact technology that was developed 10 years earlier to facilitate all the file sharing, the illegal file sharing. And out of the wreck of those disgraceful companies came this brilliant technology that then has been adopted and is actually one of the core technologies to make the blockchain work. So good comes from evil at times. So.
And one other point I think to make is that when the revenue comes in, the reality is everybody in the network knows, at least based on their permissions in the network, that the revenues come in, and that revenue can be immediately distributed, and it makes the auditing more efficient of the whole process as well.
Right, and think about, so one more useful example here is, or use case, you know, in movie productions, film production, it's not like a static situation where you know up front who's invested what. Investors can come in over time, right? So if you have if you let's say you're the first investor, right, and more investors are coming in, you always know what share of the pie you have as the new deals are cut with new investors. So it creates like a very high level of transparency there, which can be actually very useful to, again, create more efficient markets.
So how does blockchain work? If you can give a kind of a high level.
So the key, so the blockchain, the term comes from this notion of the chain of blocks, like you see here, right? So you see the green, yellow, and red, and the idea is you have a database, you separate it into chunks or blocks, and then through cryptographic methods, and we don't have to get into today, you actually change them so that it's very hard for anybody to break those chains, the security around the data, right? the chain will basically break. And everybody will know, and then they'll know, let's say you're cheating, upfront cheating, you want to change the data to say you have 2 Bitcoins instead of 1, then you'll be caught. And in fact, if you go one, yeah. So the chain will break, yes. And then there, you catch there's some fraud going on or something weird going on. And if you go next one, and then the other, yeah, go ahead.
Did you want me to move forward?
Yeah, no, that right there. So the way, for example, to add a transaction, so we had the yellow, so the green, yellow, red. I'm going to add the purple. There's a consensus mechanism. That's the one that allows a new block of data, a new set of transactions to come in to the database. And if the chain breaks, then those new transactions cannot be added.
So
right?
basically everybody in the network has to agree, or at least 50% of the people in the network have to agree that the next block is a valid block to add it.
Exactly. So it's not just about visibility, right? If you think about it, not visibility of the data, it's about control over what everybody thinks the version of the truth is, and that's actually kind of coded into the mechanism. So that's in a nutshell how it works. So that's like the underlying architecture, and then on top of that you can put many applications. So Bitcoin is just one example, right? Where in the particular case of Bitcoin and cryptocurrency, what you do is on top of that infrastructure, you create unique tradable assets, electronic assets, which are just basically these long strings of characters that are unique. And the fact that they're unique means you can put a certain value to it, you can own it, you can potentially trade it, right? It could have monetary value, or it could just be a token, right? Like a loyalty program token, or you can put some kind of monetary value to it. And then,
so real quick, you mentioned that it's a digital asset, but my understanding is of Bitcoin or blockchain technology is that in theory you could use digital tech assets to represent real world assets as well.
Right. I mean, at the fundamental level, and if we can talk a little computer science here, but I think we can translate it into terms a lawyer can understand. The blockchain records the state of objects, and the object can be Bitcoin, it can be value, objects can be rights, objects can be your car, objects can be lots of things, and then states can be lots of things. States can be, do I own it or does Nelson own it? So that's an example of a state associated with an asset. It could be, do I own the rights or does Nelson own the rights if we're talking about copyright or a car or any other kind of object that is represented by the object that was recorded on the blockchain. So when we talk about the truth or the history, it's the truth of the state of the particular object, but then there's enormous creativity as to what states can be represented on the blockchain. I mean, what objects can be represented on the blockchain and what states can be associated with that object.
And that's the beauty of what's going on right now in the whole blockchain community is that everybody's experimenting with that. That's good. So there's the blockchain, and another word that's often thrown around in the ecosystem is smart contracts. What is a smart contract?
Yeah, so let me just end here and hand it over to Dad. But I just want to say, so in the same way you can put more applications on top of the blockchain architecture, you can put more code into it, right? So now let's say that I want to, now that we all know, we're up to par in terms of we all have the same information, right? Why don't we just automate the deals we make such that, you know, if I know that I'm a financier and a producer and a creator, and I know that I deserve, you know, a certain percentage, let's code that into the contract, into the system, so that when the money starts flowing in, let's say, you know, I sold the film to Netflix for $2 million, right? Then as soon as that money comes in, the funds are distributed, or at least allocated to all the different parties automatically. You don't have to wait You don't have to wait a month or 6 months, whatever it may be, for royalties to come in, for example. It can all happen automatically as long as the code is correct, which is, let me hand it over to that.
So, Dad, why don't you give us a little bit more of the technical aspects of the smart contract?
So I think just to take a step back, I think everybody here probably has worked with a smart contract already. You just don't know it. Automatic bill payment is a form of a smart contract. It's an if-then statement. When your bill comes in, your bank account automatically pays it. That's essentially a smart contract. And so when it's applied to the blockchain, there's all this more. The use becomes much more robust because the ability for code becomes much more robust to the extent that it can take in more external inputs, other triggers can implement other actions. And so a very easy way to think about a smart contract is just like a vending machine. It takes an input, and in response to that input, it gives out an output. That's pretty much it. And so, yeah, can we go to the next slide, please? Yeah, and so here's just an example of just a smart contract here. So this is just a couple lines of code. I won't get into too much detail about what it is, but it allows another contract to send money on the behalf. So there's just a simple check whether or not it's been approved, and then the transaction is sent. But just kind of take a look at this and just, it's not really a contract, it's just a couple lines of code. So
if it's not really a legal contract, what is it?
Yeah, so as attorneys and kind of if there are any law students here and have contracts fresh in their mind, you'll remember that the definition of a contract is mutual assent, express and valid offer and acceptance, adequate consideration, parties have to have capacity, and it has to be legal, right? If we kind of remember the couple lines of code that we had before, a simple analysis of those lines, it's pretty clear that that's not a valid binding legal contract at all. It's only written in code. The parties who are contracting to it, it's often not written by those parties. Again, those parties probably won't even understand what that code looks or does. And lastly, it again misses the basic requirements of what a contract is. So what really is a smart contract then? I think it's really a misnomer. I think the best way to think about a smart contract is, sorry, can you go back?
Yeah, sure.
Sorry, the best way to think about a smart contract is that it's the performance of a contract, meaning that it's the execution. So perhaps there's two gentlemen, A and B. They agree for a transaction to occur, and they're like, okay, well let's agree to I'll send you $5 if you send me a widget. To the extent that is the contract or the meeting of the minds, the smart contract code that is programmed to represent that transaction merely is the execution. It's no different than you telling a secretary, hey, when B sends me a widget, please send that $5 to that person. It's no different than that. Okay.
So, Dad, if it's not really a legal contract and you need a legal contract, what's really your options then? So
within the blockchain space, we have a term called the Ricardian contracts, and that's essentially the definition of that is just really a binding legal contract that can be read by a human. And so I think some platforms, EOS being one of them, actually has a requirement that all smart contracts have to be accompanied by a Ricardian contract, just so that, because there's an understanding that humans are always messy. There's an old saying that the moment the ink dries on a contract, it's out of date. It's obsolete. And that's generally true, to the extent that even in code, there's a lot of errors that can occur, but at the same time, not only errors, but human error, human misunderstanding, and then the changes of human understanding. And so there always needs to be some sort of record for the agreement beyond the code, that being the written legal contract. And so a great way to make a very, a smart contract that would protect yourself is to accompany with it a Ricardian contract. In addition to that, I also recommend recording your Ricardian contract on a blockchain and generating a hash on it, like we have here, so that that it actually eliminates the possibility of forgery as well. It's actually a very elegant solution.
And so, as I understand it, the hash of the contract is included or referenced in the smart contract, so that basically every smart contract that is implemented is referencing the real contract.
Yeah, there are several ways you can approach the problem. Some people actually include human readable or the recording contract in line with their code. So they'll include that as notes or kind of comments into the code. I don't really recommend that, because then when you get into litigation, you kind of have to parse through everything, and there may not even be a signature at the end of that. So it's always good to keep a valid binding contract. But yes.
Have there been lawsuits over smart contracts involving blockchain already?
Not yet, not that I know of, and if they have started, they haven't really been resolved yet. And I think one of the biggest problems is because, you know, I think the parties that have been damaged just kind of understand that our legal structures just aren't in the place to deal with it yet. And there's also these large jurisdiction issues too, for people who have lost significant funds of money in like Ethereum contracts and stuff. Like, where do you go? Who do you go to? And then at the end, that even if you get a resolution, right? How is a judge or a sovereign body going to force an entire network of unrelated parties to say, hey, we're gonna change or change the entire ledger to do this? And there was only one other time that the ledger had been changed, was in response to the DAO hack on Ethereum, where early on, I forgot, it was like $200 million, something like that, was locked up because, probably more, because this engineer or this coder just decided to tinker around with a smart contract. He didn't think people would just grant random people access, but so he changed the code, and suddenly all this money was locked up. And you know, he was pretty honest about it. He's like, hey guys, I did this. I didn't know I could do this. And so, you know, the network decided that they needed to fork the network, and that's a monumental task, and I don't think it can be done now. You know, if there was another hack, I don't think Ethereum or anybody else can fork it again. And so that's one of the big issues. And what I really like about
why don't you explain what fork means?
Okay, sorry. Forking a chain is when we were talking about blockchain just a few minutes ago, when we were talking about how you need about at least or more than 50% consensus, meaning 50% of the network has to agree on one version of the ledger. And so forking means that you kind of get 50% to agree, and then they all agree, hey, this is going to be the new version of the ledger, regardless of what happens, and we're going to go forward with this moving forward. And there are actually people who are still on the old version, and they're just kind of keep going on their own, but two paths diverged, and now, you know, there's two different parties doing things, and that just...
Effectively what happens is you rewind history to, and what they did in the DAO exploit is they just rewound history to the point immediately before the hack took place, and then created a new history from that point forward.
Yeah, you can see how that's...
I agree with that. It'll never happen again.
Well, you can see how that's wildly inefficient, because I mean, even all the transactions that happen subsequently, you know, those are all lost pretty much, right? And then that's why you need legal structures, and that's why my company and myself have always been pushing for legal structures within any blockchain. You know, you don't want to have to fork it, but you do want some sort of governing body to kind of make people who have lost significant sum of money whole. And a great way to do that is you just burn the coins and just issue new ones if you had to. And that very easy way to do something, but.
And to put this in perspective, you know, while our network on the screen only has 5 or 6 players, the reality is these networks include millions of people across the globe. I've heard one version where the Bitcoin blockchain takes basically the equivalent of a nuclear power plant a day to power the cryptographic functions to make the blockchain work.
Absolutely. There's issues with sustainability and you know, and just essentially human trust is very expensive. We have to pay for it in some way, and I think a lot of chains are really understanding that now, and they've come up with new consensus models that are in essence less secure, but you know, more efficient, because again, there's a trade-off, and that's why governance, identity, and other infrastructure is much more important.
So,
can you just a comment on that is that. So there's like a fundamental trade-off, which is that the more decentralized a governance mechanism is, the less efficient it is, right? Because it's built on consensus. And it applies to this technological phenomenon too, right? The more you have to get to consensus through sophisticated cryptographic methods to ensure that the data is valid and there's a single version of the truth, the more distributed that is, that consensus, the more inefficient it is, technically speaking. And so that's the challenge, right? And I think, and I guess in the short term, that makes me a skeptic a little bit because efficiency is key in business, right? So, the right level of technology needs to come so that there's a good enough trade-off between security and efficiency in order for this thing to work across industries.
So basically on the right, where it's very distributed, it's not very efficient, but it's very secure, whereas on the left, highly efficient, but not very secure.
Going back to your comment about including a legal authority within the blockchain, so and that's like creating a little government or
Yeah, there are some projects that are investigating that, and so I'm not saying all blockchains should have legal authority. I'm just saying it depends on the use and the purpose, right? And so I'll give an example. EOS is, tinkering with the idea of a constitution, a governing body. Instead of having, anybody can mine, they have what they call 21 block producers. And so it's a trade-off. You can come to consensus, or you can get people to agree or execute on certain things much more efficiently if only 21 bodies have to agree versus the entire network. And so there's a lot of benefits to that, but then again, there's a lot of other downsides. But I'll just talk about the benefits, being that now if the idea is that if you within the ecosphere have a transaction and a dispute that's gone awry and you go into arbitration with that, and in response you've won your arbitration and now you have a valid arbitration, you can take it to the block producers and say, hey, I got this judgment. Block producers will execute on it and we'll take the money back out and execute for you. And so it makes collections a very, very efficient thing, potentially, if this whole grandiose experiment works out.
So blockchain is being considered for a whole host of industries, and a number of them are reflected in this slide, but I want to focus now on what we're here for, the media and the entertainment space. And so I guess I'd like each of you to kind of talk about where you see the opportunities in the media and entertainment space. What do you think is the genuine possibilities, and what's more hype? So Nelson?
Yeah, so I would go back to the trade-off we just talked about between the decentralization and security. To me, the biggest potential will be in environments where decentralization is an important factor that's going to make the market more efficient, which is going to, the market's going to be more efficient in terms of the outcomes, even though the processing may be more inefficient, right? So there's a trade-off there. So for me, one good example of that is the advertising ecosystem, the digital advertising ecosystem. You have consumers who are willing to trade off privacy for content, but there's a trade-off to be made. You have advertisers who are not exactly sure where their ads are ending up. There's a lot of fraud and so on, right? And then the publishers are the big publishers like a YouTube and other sites are the ones who are making the big bucks because they have full control over the mechanism, even though there's a lot of intermediaries. So that's an environment where some decentralization of power may be good for the ecosystem, and I think that's where blockchain can have a big impact. And there's probably others in the
Sure, Professor Atik.
So yeah, I think there's lots of interesting media applications. I've been looking in the music industry, a lot of people are, because in some sense the huge transformations that have occurred in the last 10 years as we moved to primarily a streaming distribution model actually, I think, would make blockchain-like solutions for accounting for rights and figuring out what royalty streams are much more implementable than they were in the old days where you had performing rights societies and people auditing bars and restaurants and people ordering broadcast and so forth. So it's an interesting moment for the music business, given all that. That said, the underlying problem is very complex because we're tracing a lot of different states in music rights. We have the composer's rights and their respective rights that they may have with their music publishers, and so does that whole kind of micro set of relationship and stakes get modeled into some kind of digital format and then loaded on, or does that remain off? Likewise, performers' rights, because of the recent legislation, of course, has gotten much more complex. Many more claimants as we look back in time and forward in time in the production of music recordings. Again, what are going to be the little micro deals? Who are going to be the various stakeholders? And again, is this technology a nice technology to capture the interrelationship between the rights holders in a particular recording? So you get all of those little places for technological exploration. And then, of course, it's the exploitation of the recording itself as it then moves out, primarily in a streaming setting, but obviously there are going to be other kinds of settings that will remain. We'll still have live performances. We certainly hope, anybody who's a musician hopes that that's going to continue. Is it just going to be ultimately an accounting instrument that will be able to, with a lot more confidence, know what the actual deployment of a particular musical work is? Or is it going to be part of a much more complex infrastructure that would include really accounting that would trace all the way through to the various stakeholders, an accounting system that might enable licensing, sync rights, other kinds of uses of musical files, general licensing platforms with those works, and then finally the whole very complex stuff. And we've talked about this a couple of times when we've been on phone among the five of us. The whole micropayment problem. How do you collect the 1,000th of a cent you get because somebody in Bangalore listened to something on Spotify and make that work?
And I mean, obviously there's a number of licensing bodies, aggregators, and intermediaries that are making money on the system as it exists now, at least for the artists that are at the very top. And so how do you convince them that they should really play in this sandbox with blockchain? What's ultimately going to be their incentive to come to the table? Does anybody?
Yeah, well, I think part of what SmartChain is all about is we are kind of a think tank, so to speak, and we are really looking at all the applications of blockchain in the media industry, and it's an irony that the media or the television and film industry is still working off a 100-year-old model, and nobody's cared to tackle it. I mean, the record industry got tackled in early 2000 when Steve Jobs introduced iTunes. And the record companies were kicking and screaming. He was able to get a few record companies on board, and the rest is history. And so with SmartChain, that's sort of our idea, is to basically introduce these technologies into the media industry from an end-to-end solution, from the beginning, from the creators and the fans, all the way to the banking on the back end. And there are so many opportunities for this technology to transform this industry. And that's what's really exciting for us, and that's what we're working on now.
Where do you see?
So I think the first killer app on any blockchain is probably going to be gambling, because it's the perfect application of blockchain, mainly because normally in gambling systems you have a central party, a bookie, that profits on the asymmetry of information. Lord knows what the actual odds are, right? The bookie's just going to make it up and pay you whatever he's going to pay you, right? But blockchain can eliminate that asymmetry of information and kind of really give users real odds. And actually, on many of the blockchains now, most of the most popular apps are just gambling apps. On EOS, it's like the coin toss app. We're hoping they're going to develop something a little bit more complicated or more fun to play. But there's a lot of people getting their kicks off flipping a coin online.
Yeah, I mean, and just to add on that, the polite word for gambling in blockchain speak is forecasting markets. because it can be a football game, it can be the price of gold.
Oh, absolutely. There's an application called Augur. It basically allows you to pretty much set up any betting platform you want. Like if you want to bet on the outcome of the elections and stuff, you can place kind of like a bounty and then promote your bet, and people are going to bet, and everybody's going to get a kind of a real world like update on what the odds are. And that's great for both players, and it's also great for regulators too, because now you have there's an absolute accurate ledger at all times, so there's nobody doing any funny business with anything. And then for me, the second application would be just distribution of royalties. I don't think there needs to be large bodies, to the extent that you need some dispute resolution and stuff like that. But I think most of the times royalties are pretty straightforward. They come in, they should be distributed accordingly, and that's pretty simple. That should be managed by a smart contract, at least in my mind.
So go ahead.
I was just going to add another application. It's not so much in film, but in media in terms of journalism. And the reason is because there's convergence of of technologies that are enabling creatives to create pretty much whatever you want with VR, AR, with mixed reality, right? So reality is there is technology out there that where I could be a virtual version of myself here talking to you, and you would think it's me, right? There are technologies out there where you can have you guys heard about this term deep fakes? Deep fakes, where they'll revamp an Obama speech with him swearing instead of saying what he was actually saying. So that creates multiple versions of the truth, which is awesome for creatives and filmmaking, but it's really dangerous for the news media. So I think blockchain has a huge opportunity for not so much in wholly distributed and decentralized media mechanisms, but the credible sources of news coming together and saying, we're going to create one single version of the truth that we believe it is, right? So that out of the 10 videos and 9 are fake, we're going to record in our blockchain the real one in order to have a record, because pretty soon we're going to have 10 versions of the truth because of all these technologies.
And so basically you can look back at the blockchain and figure out which is the real version of truth.
Yes. I mean, but you have to rely on some credible bodies that are reputable, right? Because otherwise I can put in garbage in and garbage out. So
the next couple slides have different business models that various blockchain companies are trying to exploit in the industry, and certainly SmartChain appears to be in this upper space here where they're monetizing content for creators and curators. And maybe you can talk a little bit about the model that you guys are implementing and how the ecosystem works, how the blockchain is helping both the fan be engaged as well as helping the creators and curators of content and the producers.
Yeah, again, I think it comes back to the transparency and the accountability side of the technology. For fans, obviously, who want to see, good content be created, and creators want fans to obviously be a part of that as well. They obviously want fans. The idea that with blockchain, there's a level or layers of trust that we're building across the whole platform. And with micropayments or micro investments are concerned, right now, we've got crowdfunding like Kickstarter and things like that, which are working on some level, but really what those are basically friends and family who are pitching in, and there are very limited rewards involved, and it's just a very limited platform. So what we're proposing and what we're built into our system is a much more global and more robust concept with microfinance, where fans all over the world, once they've decided that they're going to back a project with a creator, we give them layers of ways to integrate and get involved and engage. And one of those ways to get engaged is to do a micro or a finance project. So if I love a director or I love a book or a concept, and if I join the community on the front end, I can actually invest early on, and then I can also, because our system's tokenized, I can engage throughout the whole process of the project. And I feel there's a layer of trust there because everything's accountable and everything's in the blockchain. So from the beginning, all the way through the process, the creator and the fans win because they're going to, together, they're going to build this entertainment. And then once it gets to the distribution and the banking side, then obviously everything's trackable and everything will be accountable at the end of it. So we're hoping that that whole end-to-end system is what's going to transform the industry. And we welcome studios and networks and producers to be a part of it as well, because we really want to be an open system and create a platform that everyone can use. So
and the idea that because everybody is sharing the same information, the fan knows I've invested X dollars.
Correct.
Here's my reward if the project is successful.
Correct. And it's very dynamic, obviously, because as a project begins and is conceptualized all the way to production and distribution, there's a lot that can happen. And it's a very fragmented industry at this point. It's actually insane that projects get made and the way they do and get funded and investors get their money back, because it's a miracle when it happens. Because when you look at the sheer numbers at Sundance, for instance, you'll get 13,000 submissions and a handful get picked and funded out of 13,000 a year. And that's just one festival on the planet. And there's literally thousands of festivals around the world. So you've got creators all over the world who are creating content, hoping somebody's to pick it up. And these people are spending their life savings and they're mortgaging their homes to create this stuff. And at the end of the day, a lot of it just gets wasted or sits in a shelf. So we're really just changing the entire industry that way.
Well, even the whole notion that earlier today the media companies were talking about classic media and how things are done, whether you're a songwriter or you're a big studio, you're producing content that you believe an audience will want.
Right.
Whereas the reality is now you're getting buy-in from your customers and consumers in the front end, so that they're telling you what content they want to consume.
Correct, and that's the term fan-based media, is that nothing gets into our funnel unless the fans really want it, and that's where this whole thing flips upside down, and that's what makes this so exciting.
So can I ask you a question, maybe also to help everybody understand? Is your business model go all full circle based on that graph we showed earlier that has all the way from the creative all the way to consumers?
Correct.
And you have a content delivery system.
Correct.
Deliver the content, everything. Okay.
Yeah, absolutely. It's an end-to-end system, and there's a lot of revenue streams that creators have no idea about and they miss out on throughout from merchandising, from licensing, things like that. Creators oftentimes are on the losing end of that revenue. So we incorporate their participation in alternate revenue streams all the way through. So if, let's say, in phase 2 of the progress, there's a brand that jumps on board and writes a big check. They believe in the project and they write a $1.5 million check to be a part of this project. Well, the creator is going to take part in that as well, not just the studio or the network.
So in the gaming industry, if you're a gamer, you spend hours and hours on the game and you earn different skins and rewards. So, Dad, why don't you talk about the opportunity in that space?
Sure. So one of the use cases for blockchain and gaming is the we talked about earlier today about digitization of nearly any asset, being it tangible or intangible. And so one of those is intangible game assets between games. So I don't know if anybody here is a gamer, but I spent the larger part of my high school years playing Diablo, mining little swords and stuff. I lost 2 girlfriends doing it. And now
I love Diablo.
And now I have nothing to show for it but just these fond memories, right? But there are companies out there that are allowing people to bring their old assets from different gaming platforms to newer gaming platforms. So it gives new life to old IP, and that's really interesting. And also allows for new IP to enter interact with other games, and so you're kind of walking from one world to another world, and you get to carry all your assets between the two. That's kind of interesting.
So, looking at Wax's website, they kind of have an interesting approach now. They're allowing influencers to design their own stickers. And so the influencer can design a sticker and then pass those stickers out to their followers, which can then put those stickers on their skins and their weapons in games so that when they're running around the battlefield, they'll have their sticker on. So, and then also they become collectibles and tradable as well. So we talked about smart contracts, the idea that the program enforces basically what the contract is, but clearly there's potential for things to go wrong. And so what are some of those potentials? I'll start with Dat, and you can talk about what Sagewise does, and then I'd like to hear from the other panelists.
Sure, I try to keep it brief, but you know, smart contract hacks or vulnerabilities are basically anything that happens within a smart contract that you didn't intend it to. The problem's exacerbated by the fact that these contracts or these little programs are holding and managing a lot of money, and so in the developer world, as a programmer, you kind of build it, and if it breaks, you fix it, and you just you're building the airplane while it's taking off. And that's fine when you're dealing with software. That's not fine when you're dealing with financial assets, because anytime there's a bug, somebody lost money, and that's just not a good thing. And so at Sagewise, what we do is we focus on investigating and exploring how all of these hacks have occurred and how all of these vulnerabilities have occurred in the past several years, and kind of develop tools to basically prevent a lot of these things from happening, or at the very least monitor how these things are happening. So you can go to the next slide. Yeah, just a list of here are the list of just common vulnerabilities that we saw, which is coding errors. A lot of times people would just pull lines of code off the internet. They're like, oh, this is a contract for sending money on behalf of somebody else. They don't really read it too carefully. They copy and paste it in. They add their code, and then as soon as it executes, something goes wrong, right? Hacks like the DAO that we talked about earlier. Some of these smart contracts are housed on a public blockchain, so the public does have access to it, and so they can come and tinker with your smart contract in ways that you didn't expect. Data inputs, again, if a smart contract is like a vending machine, you take coins that come in, and sometimes those can be fake coins, right? And your contract does things that unintended. And then lastly, just human drama, I guess, or human interactions. We just don't know how the meeting of the minds is never really that clear until you get into litigation. And so there needs to be tools within any smart contract to kind of deal with a lot of these issues, kind of take the immutability away from it. I know that's kind of very hard for a lot of people to stomach, but that's just what I believe. I think immutability is okay for certain things, but not financial instruments.
So I think we're out of time. Certainly feel free to come up to the panelists and talk to everybody and ask any additional questions that you may have. As Oral mentioned, we have a reception. You're free to stick around. We'll be having some hors d'oeuvres and some wine and beer. And also, just to let you know, we are going to send out a questionnaire to everybody later on. It's already sent. It's already sent? Thank you. So if you would, just give us some feedback on what you think would make the conference better for subsequent years. We'd love to have it. Thank you very much. Sorry, bro. That's not a problem.